Hi students, welcome to week 9. We're looking at the selection decision and contracts this week, and it's probably the most difficult area of the course that we're going to be discovering today. Really talking about how to make a great selection decision and how to choose the appropriate contract to employ the labour. So let's get started and have a look at making the selection decision. So choosing the best person for the job from the pool of applicants is probably the most difficult aspect of the selection process. All suitable applicant information from application forms, resumes, any references and documentation provided, any tests undertaken of the applicant, referee comments that you've recorded when you've checked references, as well as information gathered during the interviews must be evaluated in order to reach a final decision. So these are really tools that go into the process to help you guide your decision so that you can make a choice between, say, applicant A and applicant B. Assessment sheets rating each candidate against the selection criteria are helpful here. So you might have selection criteria down the left-hand side and then responses or a rating in the columns that follow. And comparing these between applicants can certainly guide your decision. So to arrive at the decision that you're going to make, the following selection process should be followed. So you have to look at the applications and resumes, and I like to review them after meeting with the candidate and interviewing the candidate if that's part of the process. Preliminary interviews you might have, so to determine whether a face-to-face interview is necessary, you might have a phone interview or a Skype interview. Those tests are really going to be helpful in determining how many resources you're going to put towards that. You'll also have to look at testing of applicants. If you've done any testing, then that will have to appear as an important tool. You'll have to rate candidates according to that testing. Background checks, investigation, if you look at Facebook, if you look at their social media presence of the candidates, that should be recorded. A final interview, the outcome of that, a medical interview if it's necessary, how you arrived at the decision, did you weight certain category, and if they scored well in that category they got a higher mark, and those marks added together give a higher rating, and then that rating is used to compare between applicants. The offer, how you're going to make the offer and communicate that, and the contract or mechanism that you're going to use to I'll just have to take this call, won't be a moment. Sorry about that. So we'll just have to have a look now at the hiring process. So the initial job offer is usually verbal, and you might do that over the phone by ringing the candidate and telling them they've been successful. But it always must be followed up by a written offer. A written offer should briefly state the position, wages and salary, the starting date, any special terms and conditions of employment, any benefits of employment that are part of the offer as well should be included. An often ignored aspect of recruitment selection is the need to advise unsuccessful job applicants in a tactful, courteous way. In my experience, what is probably best is to follow the same experience for the successful candidate. So you might give a call and some feedback initially over the phone about them being unsuccessful, and let them know what the outcome is going to be long term, and you would follow it up with a one-page letter just saying that the outcome of the application process for those people. I think it's an important step. It's an important step in terms of marketing your organisation and keeping people interested in working for you. So now let's have a look at privacy aspects. Privacy provisions do not apply to employment records per se, and we've talked about this in previous lectures. However, during the selection process, no contract exists between the applicant and the employer, and therefore the privacy provisions do apply. As a result, due care should be taken to conform with the legislation, especially keeping information confidential. Both physical and electronic records must be protected, and you must provide access in certain situations to records about the unsuccessful candidates. Employers' decisions are based on accurate, complete and relevant information, so you have to make an attempt to make sure that all the information you have about applicants is correct. Where the reason for rejection is that another applicant was more experienced or better qualified, unsuccessful applicants should be advised of this in a tactful and legal manner. Where an applicant is rejected solely on the basis of adverse information, the employer should discuss the matter in general terms with the applicant without directly disclosing the source of content or the information. Accurate and extensive records of all interactions, including phone calls and interviews, is essential during the process, and it ensures that the company is prepared in the event of any legal action. So you really have to prepare these documents thinking that that might be an outcome, and that way it will let you think strategically about what you need to record. Application forms completed by unsuccessful applicants should be returned to them if requested, or destroyed once they are no longer needed to satisfy either employment or legal requirements. Alright, so if we go on and have a look at the employment contract now. A contract of employment is the legal aspect of the agreement that exists in every employment relationship between employer and employee. It's a legally binding contract that is made, and when the person to whom the job offer is made accepts that offer without qualifications, then a contract forms. So let's have a look at common law contracts. These are contracts that are outside the modern award, outside EBAs. The terms of the contract can be written, oral or implied. It is not essential for the contract to be written. A written contract is chosen by employers because it allows for cutting down any misunderstanding about the terms of the offer. And sometimes an award may require you to have a written contract if you're not going to use the provisions of the award. To avoid any future misunderstandings, this is why it's done, or legal action, it's preferable to provide a letter of offer of employment as a minimum standard. It's basically good risk management and profit people management to have that letter offer written down and communicated, sent to the applicant. Alright, common law obligations. Well, you have law obligations in relation to the payment of wages, safe working conditions and provision of work. Sorry about that, I just had a visitor knock on the door, a student, so we're back to it. So looking at common law obligations that you have common law obligations in relation to wages, safe working conditions and provision of work, duty to indemnify employees for any expenses incurred, and duty to act so as not to destroy mutual trust and confidence in the relationship that you have. So let's have a look at types of written contracts. Contracts are based on award provisions. Contracts based on enterprise agreements, individual or collective, and contracts with award-free employees, such as some professionals, managers and executives. So looking at the first category, some contracts pay above the award provisions, so they are going to want to include those conditions written down to form the contract. You may pay above the award, you may provide certain training, certain other benefits of employment that make your offer more attractive than another offer. So in those situations it's important to write those down. It becomes a contract. Contract based on enterprise agreements, so you can have a contract based on an enterprise agreement. You can refer to the enterprise agreement in the contract for employment, so basically the provisions of the EBA apply. Contracts with award-free employees, so some professionals, managers and executives, there is no award for a CEO, so you'll have a contract in those cases. So when does a contract end? So in the absence of a specific agreement between the parties as to length of time of contract of employment, you can have an ongoing contract that continues into the future with no termination date, or the length of time may be put in the contract. Let's say for a CEO, it might be a 5-year contract and then another 5-year option to take up by either party, so those can be options as well. The usual presumption is contract of employment continues until it's terminated. The period of notice required to be given by the contract or a common law may be subject to the provisions of the National Employment Standards. They're the minimum conditions, and the contract can't change those minimum conditions, or you can have an industrial instrument that applies to the employment. So implications of legislation, of course, you know what we're going to talk about here. The National Employment Standards and the Fair Work Act 2009, a very common and important piece of legislation for HR. So The national employment standards have maximum weekly hours of work, requests for flexible working arrangements, parental leave and related entitlements, annual leave and its conditions, personal carers leave and compassionate leave, public holidays, notice of termination, community service leave and long service leave, and the provision of a Fair Work information statement to each new employee. So these are very easily found on the Fair Work site. I encourage you to go to Fair Work Australia and seek out the National Employment Standards. Read them. You've probably read them before, as this is not a first year course. It was covered in a first year course in HR. But please go and review those and make sure that you understand how they're applied. In addition, there are 142 modern awards which apply on an industry or occupation basis. One such a modern award is the Hairdressing Award. Depending on the type of work performed, the modern awards are made and maintained by the Fair Work Commission, and they set minimum standards for the employment of, say, hairdressers in a hairdressing salon. The Fair Work Act also specifically preserves a number of state acts of parliament that also deal with conditions of employment. For instance, legislation regarding anti-discrimination, workplace health and safety, and workers' compensation are all preserved in legislation. If the employer is not a private sector employee, so a public sector employee, it will need to look to state legislation to ascertain whether there is a regulation of minimum terms and conditions contained in the legislation or state award or other industrial instrument. So since the 1990s, legislation has permitted and encouraged employees and employers to make their own agreements as to the minimum terms and conditions which will apply in their workplace. So flexibility is important. Legislation tries to encourage flexibility for employers and employees to come to their own arrangements and what suits them. But there are those minimum conditions in many different instruments that we've talked about, and they're important to recognise as well in any letter of offer that you send. So there is a hierarchy of industrial agreements and legislative provisions that have to be considered when finding the minimum term and conditions related to employment being offered. So there's individual workplace agreements, enterprise agreements, modern awards, and where there's no industrial instrument, the National Employment Standards will still apply. So, conditions of employment. Matters relating to the conditions of employment and general conduct of employees are best dealt with in context of good relations. So they're managed with things like a code of conduct. They're managed by documents outside of the letter of offer or the contract. And this is just good ongoing HR practice, not related to selection and decisions about who is successful. And other courses do talk a lot about these things and how to maintain great relationships with employees over time. And not everything is included in the letter of offer, but certainly what we've discussed today is what should be as a minimum. All right, so on to week 10. We've got 3 weeks to go. I hope that you're all doing well and received your comments back on your assessments. I noticed that a number of students have contacted me. I'll be getting back to those students about their assessment to provide some further clarification. And if you've got any concerns about your assessments, please get in touch with me soon. All right, take care.